This particular series of webinars is provided by us with funding given to us by Queensland State Government's Victim Services Funding Program Building Capacity 2018 to 2019. We thank them, Victim Services, Victim Assist Queensland and the Department of Justice and the Attorney General for their support. We would not be able to run these webinars without them. The program will include the webinars already on our website and a number of other webinars that we're running over the next month or two. So please keep an eye out for further updates and webinars as they come through. Community Legal Centres Queensland acknowledges the traditional owners of the land on which we're holding this presentation. For us here in Brisbane, that's the Turrbal and the Yagara people. We pay our respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this presentation is being viewed throughout Queensland and Australia, we also pay respect to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians listening to this presentation. We also acknowledge the disproportionately high rates of domestic violence experienced by Aboriginal and Torres Strait Islander peoples and the additional challenges this creates in responding to this issue. Some of the information that we discuss in these webinars can be difficult and confronting. Please take a moment to read the important information on this screen in relation to keeping safe and viewing our website page on that issue. Legal information can change. Please note the legal disclaimer on this page and make sure that your information is up to date. Our presenter today is Natasha Tanirau-Stanley. Natasha's maiden name was Pettit. You may know her by that name as the Principal Solicitor of YFS Legal. Natasha's currently on maternity leave and due back into that position in the middle of the year, but she's kindly come out of semi-retirement for us today to give this presentation. Natasha's admitted in 2010 and has worked at YFS for 5 years, so she's very specialised in representing children and young people in criminal law and domestic violence matters. YFS Legal is providing some of the respondent duty lawyer services at Beenleigh Magistrates Court. Thanks very much, Natasha. I'll hand over to you from here.
Awesome, thank you. So the aim of this webinar is to discuss tools and strategies when working with young people who are respondents and applicants in domestic violence matters. Young people will commonly face hurdles in the court. So this presentation is aimed to give you hints and tips and how to deal with those. There's things that I might not have covered, but if you've got any questions, just write in and I can answer them. So what this webinar covers is the background on why this topic is important, what hurdles for young people, so what are common hurdles for young people in the domestic violence court. I'll be using a case study to go through the other things that I want to discuss. Who your client is, communication, what happens if a young person is unable to come to your office, and explain to the court about, explain to the client about breaching an order, and then we'll summarise the important points from this webinar. In relation to the law about domestic violence was covered in webinar 1, so I won't be talking about who can apply and what is needed to apply. It's just assumed that young people can apply for a domestic violence order against each other if they're in need and there's been an act of domestic violence. I find I'm quite passionate about this topic because I'm finding that in my role as a criminal lawyer that there's a lot of young people that are finding themselves in the domestic violence court as either respondent or aggrieved. Young people at a higher risk of partner domestic violence, and the law in relation to domestic violence is quite complex, and young people can, in my experience, have found it quite hard and difficult to understand the processes and the language used. It's not a specialised children in the children's court and the criminal justice system are in a specialised court. However, when you've got children who are domestic violence orders against each other, they're in the mainstream court with a mainstream magistrate, mainstream duty lawyers. So it's a little bit different for them. It can be more confronting. So as I said, the domestic violence court is not young person friendly. They're treated like adults, but they do not understand processes like adults do, and nor will answer questions and process that information as adults. The adult concepts in the domestic violence court, often young people will want to get out of court. They'll just agree to something to get it over and done with. They say they'll understand and they consent to it, but they really don't have any idea what they're consenting to. A child and young person's concept of time is shorter than an adult. So if you're talking about domestic violence orders being for 5 years, unless there's a circumstance to make it shorter, they may not think 5 years is a long time, or they may think an adjournment period is longer, or they can't really see into the see into the future, so they may think their relationship will last forever, or it might not. Or also, domestic violence courts are really busy, so respondent duty lawyers, we do the respondent duty lawyer service at Bentley, and you're seeing a number of respondents, and you've got to give them advice and then go into court, and it's a really high pressure environment. Although there are best practice guidelines, there's best practice guidelines on working with young people in the criminal justice system, and on the Legalway website, and I've referenced that at the end. In those guidelines, it does say that these apply to young people in the domestic violence court and the family court, but in my opinion, there's no specific training on working and communicating with young people, and also there's very limited support services and behavioural change programs for young respondents. So I wanted to start off with a case study, and then I'm going to ask a question on the next slide about what do you think the hurdles are in relation to this case study. So Amy is 15 years old. She's in a relationship with Greg, who's also 15 years old. Both Amy and Greg attend the same high school, and they play soccer in the same team. Greg alleges that Amy has been violent in their relationship. The violence is verbal and emotional abuse. Greg attends court and obtains a temporary domestic violence order. The conditions of the order are that Amy is to be of good behaviour towards Greg, not to approach any place within 100 metres of Greg, and not to contact Greg by any means. Amy is served with that order, attends the first mention. Amy receives legal advice from the duty lawyer and consents to the order without admission. The period of the order is for 3 years. Amy comes to the office for advice 6 months later, stating that she doesn't understand the order. She's currently homeless and is linked in with a homeless support service. Amy does have contact with her mother, and her mother doesn't think that the order needs to be changed. So in relation to that case study, there was various issues that can be highlighted. Are you able to highlight any, and just type in your suggestions?
So if you go to the dashboard at your right hand of your screen, everybody, there should be a place that you can type in some suggestions. One of the things that jumps out for me, Natasha, immediately is the issue of her capacity to give instructions, or what role her mum might play in being involved in that. Is that something that you have come across?
Yes. So
would you get mum involved in that interview process?
I think in relation to, you would see first what the lay of the land was. You first need to establish who your client is. You would first establish, do they have capacity to give you instructions, depending on how old the client is.
And that's a comment that's been made by Alan as one of the issues he's picked up, is the capacity issue.
Yeah. So that definitely is one issue. Another issue is in relation to,
and somebody else has highlighted that issue as well and said, client is Amy, not the mother. Could you apply to vary the order to reduce the no approach, up to Amy to decide whether mum attends the appointment, but could be waiving client legal privilege? So that's highlighted some of those other capacity and privilege issues there.
Yeah, and that's definitely a valid point in relation to the distance requirement at the same school and on the same sporting team. And this actually, it's been changed to allow, so there's no breach in confidentiality, or but this actually happened. So this case scenario, a young person went to court and they got advice from the duty lawyer, and they agreed to an order on those terms, and then all these things, because of that, a huge fallout happened. So there are definitely issues, and I think all those issues are actually what we're going to talk about in my next content slide.
Excellent.
So what I've highlighted as possible issues are who the client is, what her understanding of the order is, what the effect of the order was, and that Amy is unable to attend the office to confirm instructions. So Ellen raised about capacity. So when is a young person or a child old enough to instruct? There's no legislation that sets a specific age for when a young person is old enough to instruct. In this area of law, you would be a direct representative because you'll be taking instructions from the young person. The English Laws decision in Gillick is a helpful tool. It says that a young person is able to instruct if they're capable of giving informed consent when he or she receives sufficient understanding and intelligence to enable him or her to understand what is proposed. So in relation to that, so our job as lawyers is to be able to communicate information to a child so they can use that information so they will be able to make a decision. So then it raises who the client is, because if you've got, like, on a practical term, if you've got parents bringing in their children to an office, they, in all areas of their life, they make decisions for that person. They decide where they go to school, they decide all those sorts of things. So it can be a really foreign concept to a parent or caregiver or guardian that they are not the ones that call the shots. So a young person may rely on their guardians, carers or youth workers to attend appointments, so that's really important. A young person's probably not going to be mobile themselves. They're going to need somebody to bring them to the office. Sometimes they will also want that person to attend the appointment. It may be appropriate to have the person to be present for some of the interview, but not all. A young person, they're coming to meet a lawyer. To them, a lawyer is somebody who they see on TV who is arguing and standing up, and to them, they don't understand what a concept of a lawyer is, so they may be quite hesitant to be coming to the office, or they may be quite apprehensive about how you're going to deal with them. So to make them comfortable, you need to manage the situation. So often I'll have a young person, and it's quite clear at the beginning if they want to have their family in the meeting. So I would say, look, I can introduce myself. I'm happy to have your mum and dad or whoever there in the meeting. However, and somebody raised this in relation to client privilege, to legal privilege, I raise, especially in relation to criminal matters, this is far more important when you're talking about witnessing crimes and things like that. But I explain that our conversation between the young person and myself is privileged, but it doesn't attach to anybody else. Therefore, normally when you explain that, the parents are pretty happy to leave the room and the young person's more comfortable. The first thing, I think I mentioned it later on, but what's really important when meeting with a young person is that you are able to establish rapport with that young person. So whenever I meet with somebody, you've got to share some information. You've got to share information. So I will try and make a connection somehow be something that I have like a common ground, because once you have that common ground and you've got that back and forth, that young person, they're more going to be likely to say to you, oh, actually, I didn't understand what you just said then. But you need to, and then they'll be more comfortable, and then you'll be able to ask the other person to leave. Sometimes I'll then say they're really hesitant in relation to the other person leaving. I will negotiate for them to leave for the legal advice part, and then I will then they can come back in for the other part. But I always make sure that I'm confirming my instructions with the young person. It's what the young person wants to do, because that is who your client is. It's not what the parent wants to do. So as I said, so you need to establish rapport with the young person. It can be as simple as, I remember once I was having trouble establishing rapport with a young person, and he didn't play sport, he wasn't really interested in much. But then I started asking him about his heritage, and he said that his grandmother was Māori from New Zealand. Well, I'm from New Zealand. So I said to him, oh, I know how to count in Māori. And then I started counting in Māori, and then he was like, oh, that's really cool. Can you teach me? So then I started teaching him words in Māori that I knew. And so then from then we were able to establish the rapport. So it's not something that has to be over half an hour. It's something that's so quick. It could be, we have a running joke that I go for the All Blacks. So it could be that they don't go for the All Blacks, they go for the Wallabies. But it's something that that you can it's quick, and then you establish that rapport, and then they're more likely to talk to you. It's about explaining terms in everyday language, about explaining what a respondent or aggrieved means, explaining what is domestic violence, what is a breach. You need to clearly establish what you're doing. And also too, you're not going to have interviewing a young person or a child is different to interviewing an adult. You're not going to have potentially a long time to have their attention. So you need to be clear. You need to have clear messages about what you want to deliver, how you want to deliver it, and what's the whole point of this conversation. It could be, if it's a really complex matter, it could be that your point of the point of the meeting is just getting to know each other, because you're going to be in each other's lives for a very long time until the matter's done. Or it could be that you need to, say for example, with Amy, I need to figure out what she understood of the order. What's the problem? How do we change? How do we fix some of the issues that are arising? You need to give the young person, or you need to think about how they'll understand it. You can use diagrams. I find diagrams really useful for young people. I have a whiteboard in my office, which is great. So I can draw them diagrams, or I've made diagrams myself, which I will show clients about the process in court. Give young people a working example. So not just, say for example, the order is you can't go within 100 metres of that person. What does that mean? How practically does that work? What happens if that person, they show up to a place and that person is there? What do they do? Is that every place? What happens if there's a breach of the order? What is the breach of the order? What can they do? What can they not do? It's also about having a conversation with a young person and asking them to tell you what they understand. What do they think this means? What do they think the next court date's for? How do they think that this process is going to resolve? When do they think this process is going to resolve? And what kind of impact do they think it's going to have? It's all about communicating in a way that they will understand and they'll take away meaningful messages. So one of the issues is that, so I'm going to take instructions from Amy. However, she can't always attend the office. How do you think I could obtain instructions from her? So if you've got any ideas, just type them in your message box. Yeah, so one of the suggestions is phone and then confirm by email letter of the time. Yep, so telephone, email, Skype. How technology has changed the way that that lawyers work with clients, hey? So yeah, so it's about finding different ways to communicate. It could be telephone, text, or Skype. When text, or quite often I will text a young person. Young people will not check their message back usually. I don't check my message back usually. Young people often won't accept a private number call. So if you're going to call from a private number, you've got to let them know that that's what's going to occur, and it's likely to, they're likely to get a call from you as a private number. Sometimes I will text the client and say, hey, I want to give you a call, am I able to? Often they don't have credit. So sometimes they can't text back, so you can give them a call. And then likewise, they have credit to call to check their voicemail. Also, young person or child's telephone number will often change. You need to check that it's current and it's safe. Sometimes you can communicate at court. You'll be very careful about the communicating at court, it being a high pressure environment, and they're able to are they able to give you instructions in that environment? It could be that you ask them to attend a court a little bit earlier in the morning, and then you've got some clear time you can put aside to them, and you can meet in a room at the court to go through what you want to talk to them about. It's really about knowing what, like I said earlier, knowing what you want to say and how to deliver that in a clear message. You have to, with young people, it's the same with interviewing them. You don't get a lot of time, so you've got to be able to take away information from them and quickly, and be able to communicate that back to them quickly. Also too, she was engaged in with permission of course, she is linked in with a homeless service. So it could be that service provides transportation. So quite often with, of course, if the client agrees to this, we contact their support services, and their support services can bring them to the office. Because normally, to be honest, Skype and telephone and text are all great ways, but nothing I think beats face-to-face, especially the first kind of meetings to establish the rapport. And also too, we will travel to clients if we're able to be able to obtain those instructions. So some of the hurdles in relation to Amy was that Amy could not approach Greg at any place. She had to, so what happened? She actually ended up leaving school, and so she didn't finish the year out. So I think she was in year 11. So she ended up not finishing that year. She had about 6 weeks to go. She couldn't play soccer anymore, so she had to change teams, but that nearest team was 60 minutes away, and Amy didn't have any support. But she managed to get there, but her brothers and sisters played on the same sports field as Greg. So although they went on the same team, Amy's brothers and sisters weren't on the same team as Greg, they were on the same place as Greg. So what meant that Amy couldn't go and watch her younger siblings play sport. So what I did is I explained the orders to Amy. I explained to her what they meant and the possibility of making the application to vary. I was able to obtain instructions via the telephone. I met outside the office. So what happened is we made an application to vary. However, when we went to court, we had to negotiate the terms. So this is where communication is really important. Amy no longer played soccer at the same club. So she said, it doesn't matter that so it doesn't matter about that anymore. It doesn't matter that I can be 100 metres away. Like that 100-metre rule doesn't matter. However, so she was about to agree to change the order and to leave that in. However, I said to her, but are there other possibilities when you're going to have to be in the same area as Greg? And she said, my siblings, they play on the same sports field. So Amy had thought about the variation of the order in a very narrow way, and she hadn't thought of any of the other possibilities. So checking with what she understood, then we were able to then negotiate different terms of the order, and that meant that she could still play, like she could still go and watch her siblings play, and also too she could still play, play a game against Greg if that was what was going to happen, because Amy still had to be of good behaviour. It was just we were trying to change some of the terms, which, to be honest, I don't think it was anybody's fault, but I don't think that should have been something that was agreed to on the day when there was such a huge effect on Amy's life that Amy had to leave school with 6 weeks to go, missed her formal, and then she had to change teams. But I think that came down to Amy not really understanding of what was required of her and what the impact would be, and that she just was told all this information about domestic violence, which you don't really get a lot of time as duty lawyer. We do duty lawyer, you get about 15-20 minutes, but Amy wasn't really able to articulate really what she was agreeing to. So having an order is great, but you need to explain to that person what does that mean, because what I'm seeing in criminal law is that young people are actually breaching these orders and they're actually having a significant impact. It can also have an impact on their immigration status. If they're not, a lot of New Zealanders are not permanent residents of Australia. A lot of young people don't have citizenship or permanent residency, so they can suffer greatly, and we've seen in relation to criminal law some young people being deported back to New Zealand. So you explain in practical terms what it means to breach an order. What is a breach? If a young person agrees to be of good behaviour towards somebody, what does that mean? What does to be of good behaviour mean? What does domestic violence mean? It's such a wide definition. It's not about giving a young person ideas what domestic violence is, but it's about saying it can be emotional, it can be saying this, and it's just about really having a conversation, giving examples, talking about ways to prevent a breach of the order. You don't want to see, this is a civil order, a domestic violence order, you don't want to see that become criminal. Then you're going to see a young person put into the criminal court, which could have been potentially avoided if they were referred to support programs where they really understood what it meant. Often I've seen young people have cross orders. So you've got both orders, they both have responsibilities, they're both aggrieved and both respondent, and sometimes magistrate I've seen will do it because they think that will calm the situation down. But to try and tell a young person that you can't contact this person via text when that's the love of their life and they're never going to break up, it's quite difficult. So it's about making sure that sometimes, as much as you can, making sure that orders are workable, that are going to work especially if they're for such a long period. So we're nearing the end. So really the important points from this webinar are communicating with the young people in a manner which they well understand. Really provide working examples. Acknowledge that you're dealing with very adult concepts which young people will not fully understand. Young people are likely to agree with something without understanding just to get it over with, and they often will say something just to get you to shut up. So that's why it's really important that you're not drowning them out. You're not going to probably be able to have a long conference. You probably may have a lot to talk about, but you may have to break that up in small conferences. And you need to be able to articulate what you really want to come from that conversation, because they're just going to stop listening to you. And not every child or young person is the same, so you need to tailor your approach to what they will understand. And also court dates. It's really important to explain to a young person the importance of attending, because sometimes even adults find this confusing. Like, say for example, a young person may have court dates in criminal law and they don't always have to go, and often it'll just be an adjournment and nothing really will happen. But the difference between not coming to a first court date in domestic violence order and domestic violence court could be an order being made against you. And also police officers sometimes I've heard clients tell me that they say, oh, you don't need to come to court, which technically is right. You don't need to come to court, but an order, they're not like criminal law where it's a failure to appear and you get a charge. It's a little bit different. But if you don't come to court, there will be likely to be an order made against you.
Sounds good. Did you want to talk through those resources at the last?
Yes. So if you ever have a question, say you have a question about working with a young person, and regardless in any area, I'm happy for you to give, well, I'm not going to be there till July, but happy to give the team a call or an email to talk through any issues, or you've got a question in particular, a young person's facing something and you want to get some information about that, happy to do that. To have a look at the best practice guidelines for domestic and family violence, which I'm sure you already have. And there's also best practice guidelines working with children and young people. Is mainly to do with criminal law. However, there are some really good tips in relation to working with young people that you could use when it comes to family and domestic violence.
Thanks, Natasha. If you've got a question for Natasha, type it in and I'll ask it of Natasha and get her to answer it while she's here. We have had one question come in during the course of the webinar, just confirming that these domestic violence matters are going to go to the domestic violence list in a magistrate's court. They're not going to go to a children's court.
No, they go to the they'll go to the magistrate. There has been times where I have argued for that to go down to the children's court. Often they want to keep criminal matters and domestic violence matters together. So you can often, if there's a criminal matter, you can get the domestic violence application down with the breach, or with a criminal, like associated criminal law matter. My opinion is they should be dealt with in the children's court, and I believe that there's the legislation provides for them to be dealt with in the children's court, but often they're dealt with in the magistrate's court.
The standard practice seems to be, if it's a domestic violence matter alone with no associated criminal matters, breach or otherwise, it's in the magistrate's court's normal domestic violence list. Yeah.
So there's another question come through about the DV order for 5 years for youth. So this is the whole the thing is that this is a law that is not tailored. When you've got criminal law for a young person, they're charged like an adult, but they've got sentencing like a youth under the Youth Justice Act. So there's different principles. There are not different principles in relation to working with young people in domestic violence. It's the same law. So my understanding is that it's the same. It's the 5 years unless it's an exceptional circumstance. There could be case law that comes out that says that a young person, that is an exceptional circumstance, but that could be something that you can negotiate. You can negotiate the term potentially with police or with the other side, and it could be something that you agree on. The magistrate will allow you to have a term less than the 5 years, but just because they're a young person, they still have it's the same conditions as it was an adult. So it's an adult law that would just plop in young people into. I think that's where you kind of that's where you get a lot of issues, because you don't and domestic and duty lawyers with aggrieved and respondent. I know I focused a lot on respondents, but it's the same really with aggrieved. Like we also represent respondents and aggrieved. We don't just do one category. I represented aggrieved. Really, I've just been there at court. She's seen the duty lawyer, but she never understood really what the duty lawyer was saying. So I really was there to relay information. So I really didn't do. It was more that I met with her in the office, and we had that connection, and she trusted me. So she trusted that I was going to be at court with her, and that everything was going to be okay, because she was apprehensive about the process. So it's sometimes really, and it's about having that trust in the person, and being able to communicate that way.
A question came in earlier on that related point of dealing with police in negotiations, or when trying to make an application off the first port of call, I suppose, and that whether you find that the police can be a bit dismissive when it involves a young person, and what might be some approaches to getting around that.
Well, we've found, and really our experience really is in Bentley, but we've found that really when you're dealing with a young person, it's really about what the police, especially the police, what they really want is they want to avoid this behaviour continuing to be an adult. So if you can talk to the police and negotiate, say they can't do, I don't believe they can do a behavioural men's program, because they say they're too young, say they're 14 or 15. But if there's another program that you can find for them to enrol in or something, then you're more likely to get some sort of traction with the police. They don't want the young people, especially, they don't want them to become adult offenders. They don't want them to become adult respondents. They want to be able to stop. So if you can you really need to, when you're negotiating with police, I think you really need to acknowledge their age. That is with a young person does not think of consequences in the first action. So say, for example, I'm driving, and then I feel like somebody's annoyed me and I want to do something. I want to maybe nudge their car a little bit. I know if I nudge their car, something's going to happen. I'm going to have no car. I'm going to be in trouble with the police. Or like as soon as the thought comes into my mind, all the consequences come flooding in. A young person does not have that ability. I don't think you get that ability until you're like 20. I think it's a long time. So they don't have that ability to see an action and a consequence at the same time. So it's really about, that's kind of your greatest asset is their age, and about negotiating the terms of any orders. Because I know in Bentley they negotiate directly with the police and then hand that up to the magistrate, hoping that would be acceptable. Yeah.
Have you had much luck in getting the terms of the orders down from the mandatory 5 years based on the age of the child or the length of the relationship, if it's a relationship between young people?
We've had some success, but that's all by negotiation.
Yes.
And then we've given that to the magistrate, and the magistrate has agreed to it. So it may depend on, we have one magistrate down there, so it may depend on magistrate by magistrate. Also too, you often with the aggrieved duty lawyer, say we respondent, often they kind of understand too that it's, especially if they're 14 and we're talking about a 5-year order.
Mm-hmm.
And also too that if for 5 years you can't go within 100 metres of each other, you're going to have the same friend group. Because really the most important bit is about preventing the violence. So the young person would still have the obligation to be of good behaviour. They would still have that. What's the risk to the aggrieved? It's all about risk. It's about risk planning. So what's the risk?
In terms of other support services for young people, you've highlighted that the usual behavioural change programs aren't going to be appropriate because of their age. So you're looking on one-on-one type counselling. There's not a lot around.
And the problem is that there may be more. Youth justice do some in relation to relationships. So like healthy relationships. And you don't have to. My understanding is that you don't have to be on an order for that to happen, because really if you've got a domestic violence order, you will risk of breaching that order. So you're really on the cusp of getting into the criminal justice system. So you could inquire with your local youth justice office about whether or not there's a program that your young person could attend. It's really about counselling. I'm pretty sure there was a program that was directed at young people and their mums. It was like mums and young boys about that relationship. And also another thing to watch out for, which we've been seeing happening in Bentley, and I don't think this is appropriate, is that say you've got Amy and Greg. So Amy, it's because she's 15, Amy's mum can't have an order out against Amy because that's barred by legislation. But what's been done is that what they've been saying is that Amy's mum is a relative or associated person to Greg, so they've been putting Amy's mum on Greg's order. So therefore, Amy's mum's a named person on Greg's order. So what's happened is Amy now has an order out against. Amy has two people. She has Greg and her mum on Greg's order because they've kind of tried to circumvent the law and make her an associate, because they lived at the same house, made her an associated person. And so then we've had young people agree to these orders. So you've come through and you've got these orders, and then Amy can be breached for, say she wasn't good behaviour towards her mum, she's got a breach before the criminal court because of that.
Very difficult circumstances. Any other questions? Send them through. Otherwise, we'll wrap up for today. You can always contact us or our YFS after the webinar. And this PowerPoint will be made available on our website. We have got one last question. If there's an associated person, do all of the orders apply to the associated person or just the good behaviour condition?
Depends what was in the order. So you can have, my understanding is that with the named person, associated person, you can have the order you need is the mandatory one, is to be of good behaviour, but depends, there could be other conditions attached to it. But the good behaviour one is such a wide order. So that's really the one you have to watch out for, because you have an argument with mum, somebody calls a neighbour calls the police, and the police come. That's all you need somebody else to call, and that often is what happens.
Yeah, very, very difficult for a 15-year-old who is naturally going to be arguing with mum. Thanks very much, Natasha. That was a really informative session. I'm sure I'm giving the vote of thanks on behalf of everyone who's been watching. I will be in touch about picking up the rest of this webinar. Renee Hart's part about dealing with LGBTI clients. But for today, I thank you for your attendance and thank Natasha again. Goodbye for now.